Hello people, another episode of ELAVI Truth TV. Now this one is going to get very legal on you all, but I urge people to watch this because I'm going to tell you why I sacked my firm of solicitors that are supposed to be representing me in criminal trial, defending myself against charges that could implicate the judiciary in corruption. Now, as many of you know, I've been charged with saying my children's names outside, violating an order put in place by the family court. So I've been charged with saying my children's names, saying the names of judges, sending an email to the mother of my children via her solicitor, and what else have I been charged with? Oh yeah, contacting a relative of hers. They're the charges that they're bringing against me. So when I was locked up, you can see what happened when I was locked up. I took on board a firm of solicitors called Kellocks. This is them there. We're going through the players in this firm. Now I'm going to show you the corruption of this firm. They're a corrupt law firm, not acting on my behalf when they should be, because it states in your human rights, Article 6 of your human rights, that you have the right to a fair trial. That means fair representation. Not corrupt representation, but adequate representation to give you a fair trial. Now, on the 12th of October, I first met with the firm. This is outside of the police station because they're duty solicitors. Solicitors that are in the pocket of the police. They get their work from the police station. So they don't go against the police, although they'd like to tell you that they do. In the police station, I met this one who told me, oh, the police don't like me because I go against the police. Rubbish. He's lying to gain your confidence. They don't go against the police. Why? Because they get the business from the police, and they wouldn't be in the police station if they were going against the police. But let's move forward to the 12th of October. The day before I'm supposed to go to Crown Court, because they bumped it up from magistrate courts into the Crown Court. They want to charge me with as much as they can. They wanted actually to put me in prison, but they weren't able to. So I'm on bail at the moment. So on the 13th of October, I was supposed to go and plead as to whether I was guilty or not guilty. I pleaded not guilty, but the day before, I met with this one. Leslie Nicholson, the person who's supposed to be representing me, taking care of my case. At this time I'd written an affidavit and I wanted her to file it. Listen to what happened in the meeting. Listen very carefully. What I've done is I've done an affidavit and I'd like you to serve that affidavit on them. Yeah.
Right. Yeah. Well, do you want to deal with that with Miss Hackett tomorrow, your barrister?
Oh right, okay. Well, could you take this though and do me and
copy it and scan it to Miss Hackett? That'd
be great, yeah. At no time does she say there's any issue with putting an affidavit in a criminal trial. She goes on to say this.
Do you want a copy to keep and then I'll scan a copy to Miss Hackett?
Oh yeah, please, that'd be great. Photocopying a copy for me and saying that she will forward it to Miss Hackett, this one, who's my barrister, who's going to represent me on the 13th, the day after. She goes on to say this.
That's on the indictment.
And will the judge also be aware that I've done an affidavit? Because...
Well, I'm going to share it with Miss Hackett after I've finished with you.
Okay.
And then if she wants me to upload it onto the system for the judge for tomorrow, I will do.
Yeah, that'd be brilliant. No, I would...
It may be that she wants to just chat to you about it first in the morning.
Okay.
And then she'll ask me to upload it.
Okay.
Because we all work off this central system, so the judge, probation, everybody has access to this. So anything we want the judge to see, we simply just upload it onto the system. All right. When I asked her about whether the judge will have access, she's claimed that the judge will have access because it's one system, everybody has access to it. I left that meeting believing that my affidavit would be uploaded to the system and the judge would see it, because I wanted them to make sure that they saw it before I pleaded. In my affidavit,
is allegations to do with the corruption of the judges in the family court and the reason why I'd spoken out about them. High-level corruption, organised corruption, stealing of children for profit, using of family court experts to destroy families. These are the things that are in my affidavit. High-level judges, such as this one, ordering me to be assassinated or attacked whilst held in prison. Can she refute it? She will when she comes to trial. Or will she though? Because what happens the day after when I go to plead and Miss Hackett is supposed to have my affidavit? This one's Miss Hackett. She tells me, no, I don't feel like we should put the affidavit in. No, we shouldn't serve it. Don't forget, I'm instructing them. They work for me. They're getting money off the system to work for me. This is what they're supposed to be doing. So when I instruct them to put an affidavit in to serve it, they're supposed to do it. Now they have the right to say, oh well, we don't think you should do this, but if you want to, we'll do it because we're instructed by you. They didn't do that. This was the 13th of October. Let's flash forward now to December. Now in the intervening time, I have continually asked for them to serve the affidavit. They haven't done it. What Miss Nicholson has done has ignored me completely. In the end, I had to contact this one. He's the principal, Ivan Dickinson. When I contacted him, he made some excuse, and then she contacted me. This happened a few times. All this is recorded via email. I knew they weren't really representing me properly. I'd asked them to, request information from the police, start proceedings and make a complaint against the police. Nothing was done. Why? Because they're in the pocket of the police. They're not really representing me. They're looking after the interests of the corrupt judges and the CPS who want to put me in prison. But let's take it further. As I say, I've continually told them to serve the affidavit. No joy. In the end, what do? I serve the affidavit myself on the court via email. I tell them the reason why I'm serving it them, and I tell them it's because my solicitors have failed to adhere to my wishes. Lo and behold, on the 8th of December, I get this email stating that she can confirm, this is Miss Nicholson, she can confirm that my email has gone to the court, but the judge has ordered that it not be opened. Wait a minute, the judge has stated that it not be opened. She also states in this email that she will discuss this with me at the next meeting, the 14th of December, the day when my defence statement is supposed to be in. No defence statement has been done. So what can she have to discuss with me about my affidavit? There's been no issue up to now, apart from the fact that people are telling me can't be served. Nobody wants to serve it. Interesting. They won't want my affidavit to go in. But I'm going to tell you what an affidavit is. Unlike a statement, an affidavit is a document of truth, a statement of truth. And the way how I did the affidavit was to go to a different solicitor and swear on the Bible that everything was said in there is truth. Now, when you're on oath in a courtroom, you swear on the Bible to say the truth, the whole truth, and nothing but the truth. So help me God. You have to repeat this in court. And if you lie once you've taken the oath, you could face 7 years in prison for perjury. It's no different from the affidavit that I did. Because when I take it to that solicitor, he asked me this question. whilst he's got the Bible there, he says, "Is everything in this document true?" I say yes. He says, "Can you now swear on the Bible?" In the same way, if anything in my affidavit is incorrect, I would face time in prison, the same as standing in a courtroom. Here's the power of the affidavit. These people know that if it's served into the court and it's not rebutted, if nobody challenges it point for point, then it stands as truth. Now here's what would have to happen in order to rebut my affidavit. The judges that I've made these allegations against would have to come into a court, swear under oath, and rebut my affidavit. Very scary for the judges, isn't it? So let's flash forward to the meeting on the 14th, and let's hear what Mrs. Nicholson has to say first off.
That's some of the unused.
All right.
Long.
What, the unused material is long?
Yeah, it's like 82 pages. I'll just go and grab it. So, there's a couple.
I was just going to ask, is that a copy for me, the unused stuff?
I wouldn't ordinarily give you a copy of the unused. I'll have to get permission to let you have a copy. I've got a copy of...
The first thing Mrs. Nicholson says to me is that she has an 82-page document of unused material. Now, for those who don't know what unused material is, when the prosecution have a case against you, they have their case, and then they have a lot of material that might be unused. Now, that unused material could strengthen my case or your case, and you have a right to see it. This case happened in 2003-2004. R versus H and C. It inspired the Golden Rule. What is the Golden Rule? It's to do with disclosure. Disclosure. Fairness ordinarily requires that any material held by the prosecution which weakens its case and strengthens that of the defence, if not relied on as part of its formal case against the defendant, should be disclosed to the defendant. Bitter experience has shown that miscarriages of justice may occur when such material is withheld from disclosure. The Golden Rule is that full disclosure of such material should be made. We are sat here in the room with Miss Nicholson holding all the unused material, not really knowing what my defence is, but denying me access to the unused material. Denying me my right to see if there's anything in that material that will strengthen my case and weaken that of the Crown prosecution. But what has she said to me? She said to me that she needs to get somebody's authority, permission, to give me the unused material. She has violated my human rights by denying me the right to see the evidence held that can strengthen my case. Now, why would she do this if she's not working for the CPS? Let's go on to something else she said.
Now, he says here that it's an affidavit, but I don't think it will be this affidavit, will it? Because there's only us in possession of this at the moment, isn't there?
And the court.
The court have it, but I haven't opened it.
Mrs. Nicholson states that there's an affidavit, but it can't be the one that I've given because they're the only ones in possession of it. Then I state, and the court is in possession of it. She states to me, yes, the court is, but they haven't opened it. They haven't opened evidence that I've put in the case. Really? Make a note of the fact that Miss Nicholson has said that there's another affidavit. I've not seen it. Let's go on.
So I've got your affidavit. The only reason I haven't served it is because in criminal proceedings we should really draft it as a defence statement, not as an affidavit. So what I propose to do is have it redrafted and then get you back in to sign it. It'll still contain your information, but it's just the format in which it needs to be done, okay?
I was led to believe, though, an affidavit, you know, if not rebutted in the court, remains as true.
They're not used in criminal proceedings.
Right.
That's why we have to raise the issues in a defence case statement, which we serve on the court and the prosecution, and then in 14 days they have to respond, the prosecution has to respond to the issues we raise in that.
Right.
Okay. So I just have a couple of questions about your affidavit. Well, just one, not both really.
Later, after me giving her the affidavit, weeks after the last time that I'd actually asked her to serve it, at no time intervening when I asked her to serve it many times had she ever said that affidavits are not used in criminal proceedings. But right now, when there's a problem, when I've tried to serve it and some mysterious judge has prevented it from going into proceedings, now Mrs. Nicholson tells me that affidavits are not used in criminal proceedings, even though shortly before this she said that an affidavit was put in by the Crown prosecution, or it was mentioned in the case. Interesting how people, when they're lying, don't keep track of their lies. Now this person is actually lying to me and denying me my right to a fair trial, denying me my right to put a statement of truth into the courts. Why? Because she's protecting criminal judges and working on behalf of the CPS. It's disgusting to think that people who are supposed to have a fair trial are given this kind of representation from this corrupt firm. She's actually denying me my right to speak my truth, which is very important, simply because she wants to protect judges. Now, by doing this, by removing my affidavit from the case, having it not served, and then writing a statement, her and the CPS are able to dictate what evidence I'm able to get out of that 82-page of unused material. Because if I mention something in my statement, then the CPS will release evidence that coincides with what's in the statement. If I don't mention something that is in that unused material, then the CPS will keep it back. This is the reason why Miss Nicholson did not want me to see what was in the unused material. Now think about the gravity of this. Your solicitor is colluding with the CPS and a judge in the court to keep out an affidavit and to put in a new statement that will dictate what evidence you can have. Evidence that could potentially prove your innocence or destroy the case against you by the CPS, the Crown Prosecution Service. These people are supposed to be honest, but what are they? Criminals. With regard to the video, false allegations in the family court, which there's no charges for, is there? There's no counts on that.
No.
So, again, this shows that they don't want that evidence that's there to come into proceedings. And why would that be, do you think? Why would they not want that? Because in my opinion, it's because they don't want evidence of judges making corrupt actions, criminal actions in the family court.
These are the things that you allege in your affidavit, aren't they?
Yeah. What you've just heard there is me setting a trap for her to find out exactly why she's prevented the stuff going in, and she's agreed to it. She's concurred with it because I stated to her that they don't want this evidence going in because it will implicate judges, and she said, and these are the things that you state in your affidavit. Very, very deceptive. But not clever, because I never trusted them anyway. So let's go further into what is said. Let's go a little bit deeper.
Just going back to the consent with the Attorney General, have you got a copy? You've given me the letter they sent you, and then your Exhibit 8 is them acknowledging your response, but I haven't got your response
Okay.
Can you, is it via email or no, just by a normal letter?
I can't remember. I'll try and seek that out.
Have you got it?
Do you think that's important?
Yeah, just continuity, so that I've got all of them, so I can...
Miss Nicholson is now asking me about the Attorney General, because the Attorney General had threatened to prosecute me for videos. But this has got nothing to do with my defence at the moment. We've not done a defence statement. She wants to get rid of the affidavit. So why is she asking about the Attorney General? Again, is this to help the prosecution? I would suggest it is. Because the prosecution needs to find something on me that will strengthen their case against me. They know the case is weak. Let's go deeper.
Again, this is evident. They're not taking in action against me. Again, they're taking action against stuff where judges don't have to be defending their actions, such as me naming judges, but they've not really charged me for anything where the judge's actions are going to be...
The CPS haven't, no, but then that's the subject of the contempt proceedings, isn't it, with the Attorney General?
But there is no contempt proceedings. They're making threats there, but there's no active proceedings, and you can verify that if you want, because you're acting on my behalf. So
yeah,
if you was to...
so the last letter from them,
So it's clearly somebody from the family court, maybe Judge Singleton or Judge Turner, who has contacted the Attorney General in order to have this removed. The judges are in a bit of a bind, really, in my case. Do you not think?
Potentially. But as far as the prosecution are concerned, they're not concerned with they're not prosecuting you in relation to the content of the video, like you say, they're just prosecuting you for breaching the two orders that are in place.
Well, as it says in my affidavit, which you say is going to be a defence statement, the so-called breaches are breaches that they're alleging are without reasonable cause, without...
Reasonable excuse,
yeah. And the fact that the judges have acted in a criminal manner is my excuse, in the main. There's other reasons that are outlined there. So, I mentioned to you also the recording that I have of the latest, the last hearing that I had in front of Judge Brown, in which she admitted that the evidence proving that Judge Turner had acted in a criminal manner had been buried by her.
But this prosecution isn't to do with the content of the videos, though, or any judge's criminality. We need it.
Can you hear her preoccupation with the criminal case that is going to be brought against me by the Attorney General? And I have to tell her that there is no case. What's interesting is this. When I say to her that the judges are in a bind in this case, she says yes, potentially they are. But the CPS is not interested in all that. She is trying to make sure that nothing to do with judges can be said in this case. She's trying to protect the judges, and she's trying to strengthen the case of the CPS against me, the person that she's supposed to be defending. Shocking. But here's the thing as well. Why do you think she would be so interested in the Attorney General case? As I said, their case is so weak that they need something strong to justify them arresting me, stripping me naked, treating me like an animal, and bringing malicious charges against me. She shot herself in the foot, because everything she's doing here is clearly not to aid me, but to aid the system that she secretly serves. Let's go in deeper. You
know, in terms of the stuff and the criminality of the judges that I've mentioned about the audio recordings now, in the third count, it states that I've named the children and the judges involved in the case.
Yeah.
And
They say that the non-mol order prohibits you from doing that.
Right. Well,
but I haven't seen the non-molestation order.
There is the defence where I'm speaking about the judges. I mean, in terms of unused material, the video called "False Allegations in the Family Court" is unused material, because that doesn't really come into their you know, it's not really one of the things that I've been charged with. So that's unused material. That leaves a door open to bring the evidence in implicating the judges. Now, in terms of this one, where they've said that I've named the judges, well, yeah, I've named the judges, and the reason I've named the judges is because of the criminal activity that they've done. And the CPS have got the evidence there, so there's no way we can't bring that into the case. They cannot prevent that from coming into the case, no.
Does the non-molestation order specifically prevent you from naming judges, though? I haven't seen it.
It states that I'm not supposed to name anybody in the case, and that means, and this was a late addition, it was an amendment to the non-molestation order.
Right, okay. And you're saying that you accept that you did that, but you're saying your reasonable excuse is that you were doing it to expose.
Well, it says it in the video, I'm saying that in the video, and I'm saying that on the day when Judge Brown has sent me to Burnley, stating that the case is there, and then they've had in Blackburn. I've done that on that day. Yeah. But
what is your reasonable excuse that you were unveiling their criminality, as it were?
I was doing that, yeah.
Count 3. Is that your defence to count 3?
Yeah. Now, obviously, I can't make these kind of allegations in an affidavit that could end me up in prison. If there's anything in that affidavit that's not true, I could serve time, couldn't I?
Yeah.
Yeah.
Did you hear the devil's solicitor state or concur and say yes when I said if there's anything in the affidavit that's not true, it could end me in prison? She said yes. So how is it possible for the courts to put me in prison for something that's untrue in the affidavit if affidavits are not used in a criminal trial? Can you see how she's trying to steer the case away from any mention of judges? So many times in the audios that you've heard her telling me that my defence is nothing to do with judges and the prosecution won't be interested. But if you remember, she stated yes when she said that the judges were in a bind. How does she know the judges are in a bind? How does she know that? What communication has she had with judges? How has it been orchestrated that all parties in this case, whether it be the Crown prosecution, the judges in the court, and her corrupt legal firm, Kellocks, all have orchestrated that this affidavit doesn't go into these proceedings? How is that? Corruption to protect family court judges, who are they themselves the most corrupt devils that you will ever find, destroying families for profit. When this corrupt solicitor stated yes to when I said the judges are in a bind, she knows very well that no judges will be able to come into the court and give evidence because they put themselves in a point of being liable to be prosecuted for criminal activities, for violating their oath of office. They're in more than a bind with the case that I'm going to be in Preston Crown Court for. I urge people to come to that court. I urge them, not for me, I would love your support, but because you will see criminality in action. You will see why so many innocent people are in prison. Let's go deeper. Let's listen to her some more.
You know, I mean, as you say, or as you concur, the judges are in a bit of a bind, and it was always my intention to expose what had gone on in the family court.
And in effect, you're using these proceedings to reach that aim, aren't you?
Well, does the law not support that? You know, does the human rights not support that?
Well, as far as this prosecution is concerned and the prosecution are concerned, the only issues here are whether you've got reasonable excuses for breaching these orders. They're not involved in or interested, from their point of view, in the content of the video. It's just the very fact of sharing of the video.
No, they're not going to be bothered, but the law states without reasonable excuse.
Yeah, and that's what we're saying. First reasonable excuse, count one, it was, we say, and we will give evidence to say it was found with proceedings. Count two, the reasonable excuse was that was a shared date, not a published date, and the published date pre-ordered. And reasonable excuse on count three is that you believe it was reasonable to unveil the criminality of these judges. Yeah.
It's not her job to tell me what the Crown prosecution are interested in. It's her job to put together my defence. It's my job to tell her what my defence is. But she's arguing the point. Now here's the thing. The Crown prosecution do not want to see their judges, their bosses, implicated in criminality. And this underling, Miss Nicholson, is subservient to the CPS and to the judges. That's why she's trying to sell me down the river. Sell me out. Because I mean nothing to her. Even though she's supposed to be representing me in proceedings. She's trying to guide these proceedings in the favour of the CPS. Now I put in a complaint to this firm, and this one, Ivan Dickinson, has responded, refuting all my claims. I told him that it was wrong for him to refute the claims without actually hearing the audio that I'd recorded of his criminal solicitor denying me my human rights. This case is going to be very difficult for them now. Now that I can prove the corruption that's going on and how that they've tried to abuse the process. I don't want to get all biblical on you all, but I want you to know this. In the Bible it states that, and I paraphrase, Jesus in the temple states, when he's talking to the legality people, the Sadducees and the Pharisees, he states this: how can you judge the speck in your brother's eye before you take out the speck in your own eye? It's a tenet of the law. How can these judges judge us and put laws in place when they are corrupt and they haven't taken a speck out of their own eyes? And how can this solicitor say that she is representing me when she is as corrupt as they come? I don't know if you can sense the fear in her voice when I'm asking these questions. You know, when she's lying to me, lying through her teeth to me, saying that an affidavit isn't used in a criminal trial. Oof, such a lie. I don't know if I should try and prosecute this firm, really. Bring a civil action against them for the denial of my Article 6 rights to a fair trial. It'd be interesting if I did try. Let's go on with the audio.
See, there's obviously, well, you know the reason why the Attorney General have not prosecuted me for the video containing the evidence against the judges.
They've not finalised that decision yet, though, have they? Did you not say that was still ongoing?
Well, how long does it take to start proceedings? I've got the evidence.
Once again, she mentions the Attorney General when I'm trying to talk about how I'm going to use these proceedings to expose the judges. She once again tells me that the Attorney General hasn't finalised their decision not to bring proceedings against me. But how would she know this if she's not in collusion with the judges? Earlier on, I stated to her, it must have been a judge from this court who spoke to the Attorney General for them to threaten me about the videos. I've not been charged with any of the material to do with the judges. Interesting. Videos that clearly show criminality to do with judges I've not been charged for. But saying my children's names I have been charged for. In the last little segment I'd like you to listen to, it is about what I've been charged with and the names. Listen to this and then we'll close.
The video is online. It's called I Want My Children Back, and it's the only video in which I've named my children and named 2 judges. So these other videos that are part of the case, are they basically trying to help my case by putting these in there?
I just think it's really badly prepared by whoever's prosecuting it. I don't think they've cross-referenced what videos are actually what, if I'm totally honest. But
they haven't got the video in there, so...
No, it's referencing on the police officer's statements, but yes, it isn't an exhibit. So it's the one that recorded on display, yes?
Yeah, and the case is shabby and weak, really.
I'll agree it's shabby, yeah.
It's interesting when I say to her that the case is shabby and weak, she states, I'll agree that it's shabby, yeah. The reason why she doesn't want to agree that the case is weak is because she's working for the CPS and she's not going to tell me that the case is weak. But if the case was strong, she would say that, and she should, because it's her job to be honest with me and tell me how strong the case is. The reason why she doesn't say anything in response to me saying that the case is weak, because she doesn't want me to know the truth, that the case is very, very weak, and my case is very, very strong. As you've heard, I'm not just going in there to defend myself against these trumped up charges. I'm going in there to destroy their system, to destroy and expose criminal judges. It's a very powerful position I'm in. They know it and I know it. The only thing they can do is this kind of trickery, deception and corruption. Now, I've not said anything about the mother of my children in this video, because here's the most horrible and nasty part of it all. The system, these judges, these corrupt barristers, this corrupt firm that's supposed to be representing me, or were, I sacked them. They're done, they're through, they're gone, I sacked them. Listen, wouldn't be able to happen if there wasn't a hateful individual, the mother of my children, who has done everything she can to destroy me as a person and as an individual. It's hurtful to know that somebody could be that spiteful, hurtful, and want to destroy you to the point where they'll use false allegations of rape, didn't work, false allegations of abuse, false allegations of criminal damage, false allegations of threats, false allegations that have never worked. And look what it's come down to now. The fact that I've said my children's names, the fact that I've said judges' names, and the fact that I've sent an email to her solicitors, who I'm supposed to be allowed to send an email to, but they're stating because the email wasn't to do with the family case, I'm going to be prosecuted. They're clutching onto little straws, which is all good. I'm not clutching onto any straws. I've got proper ammunition to bring into that case. Proper ammunition against criminal judges. Corrupt, degraded criminal judges. I like to use words like that. Corrupt, criminal, degraded. And what else can I say? Satanic judges. Reason being is this. There is natural law. And there is the corruption of natural law. What these judges do is they corrupt the law. They take an oath to dispense justice, but they violate that oath for money. And then they put innocent people into prison for money. and they corrupt the system that is supposed to be so-called the best in the world. No, it's not the best in the world. Everything that we look at as our inalienable rights is being taken away from us. And I'm glad that I've been put on this planet. You know, I'm not glad that my children were stolen from me, because I love those 2 little children. I love them with all my heart. But I tell you this, as a result of them getting stolen, and then I saw the evil that their mother could do. Because I remember, I'll never forget this. I'm going to tell you this. I'll never forget this day. When she, in a court, claimed, her and her barrister, this one, claimed that I had raped her. When I saw no emotion, just cold wickedness on the face of the woman, I realized that I had been spared a terrible, terrible fate, because I believed that she was a good person. No. Anybody who lies and cheats, like these barristers and judges, they're wicked people. And I'm the reckoning, the fire one. And I'm going to show them what I am on the 7th of December 2021. Let's bring it on. ELAVI TRUTH TV. I'm gone.